She fought for what she believed in.
Now, this was, you have to understand, this is 3 years before Graham versus Connor. The reason I'm saying that is, prior to 1989, if you wanted to sue the cops under the Federal Civil Rights Statute, which is Section 1983 of Title 42 of the United States Code, so it's 42 U.S.C. 693. If you wanted to sue the cops for using unreasonable force on somebody, nowhere in the Constitution are you going to find the words unreasonable force.
Right. Okay.
You'll find the words that there should be no unreasonable searches or seizures of persons, places, or properties.
But not for
So
us.
the person, so an unreasonable seizure of person is kind of tossed in there. Okay? So, but prior to 1989, prior to Graham versus Connor, the standard for the use of force by a cop on a detainee or an arrestee was the shocking to the conscience standard. So that the actions of the officers had to be conscience-shocking behavior in order to, and it was under something called substantive due process.
Substantive due process.
Like anybody that thinks that there's such a thing as the law is incorrect. And anybody thinks that there's such a thing as the original Constitution is again incorrect.
Okay.
It's all made up. It's all of it is made up. Everything.
Yeah.
Lincoln was a great guy and a brilliant man, but he was wrong about one thing. We are not a nation of laws, we're a nation of men. That's what we are. And you can have all the laws you want, but if you get to a criminal trial and the law dictates X and the judge dictates Y, and the Court of Appeal issues an unpublished opinion saying, go take a hike, the law isn't what it says, it's what it does. Okay? And in the real world, you have very few rights, if any. You know? And there's this political dialogue going on in the United States, a fake dialogue. There is no anybody that thinks there's such a thing as the Constitution have never read a U.S. Supreme Court case.
So you and I are in agreement on this point, sir. You have made an excellent point, and I hope that it's imparted well to the viewers, because this is profound.
Listen.
This is profound.
Nobody gives a crap about your rights. They just care about theirs. You know, when Nancy Reagan in the 80s going around saying, just say no to drugs, just say no to drugs. You know, everybody was saying they would have polls from whatever, Joe Johnson's poll, I don't know, whatever polling company. And the poll said, would you give up some of your right to privacy to fight the illegal drug trade? And, you know, and everybody said, oh, yes, and all that, because nobody thinks it's going to happen to them. They can't imagine that it could possibly happen to them. So they don't give a crap, and they don't know what their goddamn rights are anyway. All a bunch of morons. They have no idea. You know, the people jumping up about the Second Amendment right, the Second Amendment gun rights, that wasn't a right until 2010.
2010, yeah. Right,
Yeah.
Obama.
And they should all go read McDonald versus Chicago, which is the majority opinion written by Justice Alito, who's the most conservative guy in the court. Him and Justice Thomas. But in order to make any of the Bill of Rights binding on the states, including the Second Amendment, they have to use the liberal doctrine of selective incorporation. And, you know, for example, in the Fifth Amendment of the U.S. Constitution, among other things, it says you have a right to indictment by grand jury. Okay? You have no federal constitutional right to indictment by grand jury in a state court. The Fifth Amendment also says, do you have a right against self-incrimination under the federal Constitution? You have a Fifth Amendment right in a state criminal proceeding under the federal Constitution not to incriminate yourself. So what am I saying? So one clause of the Fifth Amendment was incorporated upon the states in 1964.
Miranda.
No, not Miranda.
Oh.
Miranda was 66. Brown versus Texas.
Oh, it's Brown. Okay, but Brown versus Texas. Okay, sorry. Mm-hmm.
Okay, and then all Miranda and people, people are really I think Miranda, all Miranda. We'll talk about Miranda.
People are very confused about Miranda. We'll talk about
They
that.
don't understand.
They don't understand
The
that.
cops they don't have to read your rights when they arrest you.
No.
There's no law that ever said that.
Yeah. Right.
It's all Miranda says.
They're all confused when it
All
applies.
Miranda says is that if you're under arrest and the cops want to interrogate you, that they can't use your answers to their questions in the prosecution's case in chief against you in court unless you get up in the stand, and then they can use your answers because it's not a license to lie. And notwithstanding the fact that Justice Rehnquist, who's a pretty conservative guy, he's appointed Associate Justice by President Nixon and appointed Chief Justice by
Reagan.
by President Reagan in 1985.
Yeah.
Said that Miranda was constitutionally based, that it did arise out of the Fifth and Sixth Amendments, since Miranda is a requirement that the cops advise your Fifth and Sixth Amendment rights. That's what it is. Mm-hmm. But yet, when some biker who got kicked out of a county fair sued for violation of Miranda, and as a civil matter, after the criminal case was dismissed against him, because his confession was used to procure his criminal prosecution, but it didn't go to trial.
Right, because it was dismissed.
It was dismissed before trial. So, but the guy sued. In other words, the guy admitted he was guilty, but the judge ruled. No, the people had no other evidence. The state had no other evidence other than his confession.
Statement, right?
Okay, mm-hmm. So the only evidence of the crime, in other words, and in California and Georgia, some other states, there's a rule. It's called the Corpus Delecti rule. Mm-hmm. And Corpus Delecti means the body of the wrong. Okay, so in Georgia or California, and I remember State Bar Georgia, State Bar California. Mm-hmm. If I walk in a police station and said, that murder we in the paper from the little girl down the street, I did it. I did it. Lock me up. And we go to trial, and the only evidence they have is my statement, I did it. Can't convict me.
Right, it's not enough.
You can't be convicted on your confession alone.
Right.
But anyway, I think it's Venegas, something like that. Venegas, the civil case decided by Justice, I think it was Exclusio, sued for violation of his Miranda rights because the confession that they obtained in violation of Miranda, without warning, advising of the right counsel right against self-coordination, that's what resulted in his criminal prosecution. Once they got excluded, the DA dropped the case, not us to sue. But the Supreme Court wasn't going to let him sue for that. They just aren't. I mean, it doesn't. You can talk about, this legal principle must lead to this conclusion, or this logic dictates that based on this legal principle.
That's not how it works.
That's all BS. No, the judges look at the case. They tell their law clerks, here's the goal line. Here's the result.
Work backwards from that. Exactly.
Okay, that's what you do.
That's what I learned my first year in law school.
That's reality.
Yeah,
okay.
that's reality.
Okay, but anyway, so what I was telling you about Selective Incorporation is that the Bill of Rights was never meant to apply to the states. The Bill of Rights was only a restriction of the power of the federal government. It was a compromise between the Federalists like George Washington and Benjamin Franklin and Alexander Hamilton, and the Anti-Federalists like Jefferson and James Madison and their pals. Because the Federalists understood the term, and I probably got the Latin words mixed up, but Exclusio est Alterius Unius. And you heard that in law school too. But what it means is that if the law says the following acts are prohibited, A, B, C, D, and E, if F ain't on the list and ain't prohibited,
right.
Okay?
Right.
So it doesn't exist as a prohibited item by the fact that it's not within the list that specifies the items.
Right.
So the founders didn't want the Federalists didn't want the Constitution, the Bill of Rights, to be viewed as the exclusive laundry list of those fundamental rights that you have as American citizens and all that.
Right.
But the anti-federalists, which became the Democratic Party, wanted a minimal guarantee of certain rights. And so the compromise was put them in, but put a proviso about those rights. And the proviso is the Ninth Amendment. And the Ninth Amendment says, all those rights not herein enumerated in this Constitution are retained by the people. So all those rights not herein enumerated, that is listed,
Enumerated, right.
in this Constitution. So if they're not, those rights that are not in the Constitution
Are retained.
are retained by the people.
Right.
So what rights exactly are those rights that are retained by the people that aren't listed since they're not listed? Well, they're the right to wear a condom. Griswold versus Connecticut. Okay?
Bless the Connecticut folks.
They're the right to have an abortion. Roe versus Wade, Ninth Amendment. And various other blue sky law stuff.
Yeah.
Where
Privacy. Like
when I was in law school in South Carolina, you could buy toilet paper on Sunday, but you couldn't buy Hot Rod magazine or something.
Right.
Okay.
Or alcohol. Yeah.
Or liquor or something, whatever, alcoholic beverages.
Was a new woman in this life. Short upon the earth now was her time. Of all the seeds she'd sown, and the people she had known, deeply did she touch the soul of mine. She called a spade a spade. She stood on the edge of reason, and even faced with death until her final dying breath. She fought for what she